Yes, para for dictation 5 seconds to start. 5, 4, 3, 2, 1. However, it is settled that even where the state acts in its contractual capacity, it does not cede its constitutional character and remains bound by the obligations of fairness, non arbitrariness, and reasonableness under Article 14. Full point. A writ court is entitled to judicially review the action and determine whether there was any illegality, perversity, unreasonableness, unfairness, or irrationality that would vitiate the action, no matter the action is in the realm of contract. Full point. Having said that, we must add that judicial review cannot extend to the court acting as an appellate authority sitting in judgment over the decision. Full point. The court cannot sit in the armchair of the administrator to decide whether a more reasonable decision or course of action could have been taken in the circumstances. Full point. So long as the action taken by the authority is not shown to be vitiated by the infirmities referred to above, and so long as the action is not demonstrably in outrageous defiance of logic, the writ court would do well to respect the decision under challenge. Thus, where a contractual employee is terminated on the sole ground of ineligibility, the court is entitled to examine whether that ground is factually correct and whether relevant material was properly considered. Therefore, once it is demonstrated that the appellant studied statistics as principal subjects in this postgraduate course and the competent departmental expert, expressly certified his eligibility, the insistence of the state on a contrary conclusion becomes arbitrary and unreasonable. The litigation history further shows that despite repeated remand backs by the High Court, the authorities failed to conduct a fair and comprehensive reconsideration in the present matter. For the said reasons, we hold that the appellant possessed the requisite academic qualification when reasonably construed in the context of the advertisement dated 7/11/2012 and the surrounding circumstances and the impugned judgment of the division bench affirming the decision of the single bench, is unsustainable and warrants interference of this court. The present appeal is accordingly allowed. The impugned judgment dated 29/2024 in writ appeal number 1536 of 2014 affirming the judgment dated 29/1/2024 is hereby set aside. If the appellant is otherwise not disqualified, the appellant shall be restored to service on the post of monitoring and Evaluation consultant within 4 weeks from today. Full point. All consequential benefits shall follow. Before parting, we clarify that this judgment is rendered in the peculiar facts and circumstances of the present case. Stop.